Welcome back to the channel. We're here at Savills HQ in London, where I've been attending the 10th anniversary the Letting Industtry Council event, and I'm joined by one of the speakers, very well known in the private rented sector, Solicitor David Smith. And David was updating us on the Renters' Rights Bill. And David, as your speech went on, I found myself getting more and more frustrated.
Okay.
And I'm going to just bring up a couple of points, and I'm actually using the Independent Landlords blog, 12 key provisions in the new Renters' Rights Bill, which I do recommend you read because it's a great summary. You're name-checked in it.
Yes, Suzanne is. I know Suzanne. It's a great. She writes good stuff.
She does. So first of all, we've got to say it's a draft bill.
Yeah.
It's not totally set in stone yet. There's time for a few tweaks, but you're not
it
very
won't change much.
optimistic about any major changes, are you?
No, I don't think it'll change a lot. The government's quite committed to this. They've obviously taken a version of the previous one that was done under the Conservative government and tidied it up a bit, but and also they don't have the same pressure on them as the previous government because they have a vast parliamentary majority. So the prospects of getting big change are quite low, really.
So don't get your hopes up there. Obviously, the kind of big headline was the abolition of Section 21. Nothing new there coming through from the Renters Reform Bill. I think it's kind of stolen the limelight for some other kind of reforms that perhaps haven't got as much attention as they deserve. Would you agree?
Yeah, I mean, obviously people get very excited about Section 21 and fixed terms going and things like that, but in the end, I don't think they'll move the dial as much as other things. At the end of the day, most tenants leave of their own volition. It's only quite a small number of tenancies where landlords serve Section 21. There are other grounds of possession. The courts remain the same, slightly hopeless system that they are now. It's the new subtle changes that I think are more critical around rents and things like that will really matter.
I mean, with regards to the periodic tenancies, something occurred to me because there's no fixed term now, and the minimum period that the tenant can stay in the property is 2 months. So isn't that creating a grey area between short-term rentals and somebody that is using a dwelling as their permanent residential address? And isn't that going to maybe attract short-term guests into buy-to-let properties when the landlord has a mortgage on a buy-to-let activity basis, not short-term rentals? I mean, does that make sense to you?
Yes, I mean, the Airbnb light complaint was other platforms are available, I should say at this point. But that was the complaint about the previous bill, and was the reason that an amendment was put in that said that tenants couldn't give notice, I think, within the first 4 months. So it was a 6-month period. And I think the area where this is really serious is London to an extent, but particularly places in the West Country, people go for holidays, and where there is a significant differential potentially between the rent on a short let and a standard dwelling rent. And I think there is a risk that in some cases people will take the property and then immediately give 2 months notice, because they may not use it for the whole 2 months, but some mates might stay for a couple of weeks and some other friends might stay for a couple of weeks, and it'll still be cheaper than if they'd taken the property on a short let basis. And the government's not very minded to listen to this point, because their point is that they don't really want tenants bound into poor quality property, although there are other mechanisms by which tenants can leave property that's substandard. And then also they think because tenants have to pay money to move in, it's going to cost too much for them to do what we're suggesting will happen. So they don't really buy it as a story. One way for landlords to combat this would be to provide less stuff in properties, so you make sure that key things are missing. And you, don't provide a fridge or something that a short let property would always have, but an ordinary rental doesn't have to have. So I think one way And it's a problem. It's a downside because it will actually mean that tenants will get less of a turnkey solution potentially in properties, as landlords who feel that this might happen to them a lot find ways to combat it.
Yeah, well, it might deter landlords from providing furniture because...
Yeah, there's always the possibility we'll move back to unfurnished let rents. And of course, you should bear in mind that other countries where the kind of letting structure we're moving to is very common, like Germany, for example, generally provide completely unfurnished property that's very like socially rented property, where it's literally bare. There's no cookers, no white goods, no carpets, curtains, nothing. It's a bare shell. And that's what you would expect to find in the private rent sector in Germany. The UK has tended towards a very different structure, where properties are provided almost in a hotel structure, where everything's there, including right down to your cutlery and TVs and all these things. But obviously on the basis that renting tends to be a shorter term thing. If we change to a different model, then I can see that in some sectors of the market, properties may well be provided as more of a bare shell again.
It's very interesting because there's so many, ramifications of that. I'm concerned they actually haven't been properly thought through. If we move on now to conversion of ASTs into periodic assured tenancies, again, when buy-to-let mortgages came in I think 1996, somewhere around then, they were actually brought in because of the assured short-hold tenancy that gave the lender confidence that they could regain possession of the property if needed. Do you have any indication how the lending industry has reacted to these changes? Because, they're going to be impacted as well.
Yeah, there is a ground for possession specifically for mortgage lenders, which is a retweaked version of an existing ground. So I think that's there. I believe the government's talked to banks about this, but I was speaking at a valuer conference recently, and one of the things the valuers made the point that it was more likely than not that buy-to-let lenders would revalue their pricing and their loan-to-value ratios in respect of rental properties. So one of the things I think is going to be a bit of a crunch for landlords coming up who have perhaps not yet remortgaged is, of course, higher interest rates, so more expensive lending anyway, plus a secondary revaluation of percentages, but also buy-to-let loan-to-value ratios as lenders revalue the risk effectively.
Yes, wow, that's very interesting. Also, landlords need to be aware of this commencement date, which is when the periodic assured tenancies come in to existence. Or we don't have that date yet,
Nope.
But when it does, it applies to forward arrangements, but also existing arrangements. So when the commencement date happens, landlords are going to have to take action, aren't they?
Yeah, as the bill is written, and things could change, and it might change in regulations quite near the end date, but the plan is that all tenancies will immediately convert to periodic assured tenancies, both existing tenancies and obviously any new tenancy that comes into effect. There will be transitional arrangements for landlords, for example, to give new written statements that correspond with the requirements of the legislation, whatever those will be. We don't know what they'll be yet, but they'll be time limited. And then landlords who want to rely on Section 8 notices will have a very short time period of just 3 months after commencement to make use of those by going to court, so they can't shilly-shally around about it. Student landlords will only have a month if they want to serve a Ground 4A notice. So there's a whole load of changes that are quite tight. And of course, landlords will have to sign up to PRS databases and redress schemes and all those other things. And they'll have a period of time to do so, but it won't be very long. It's sort of a concern to me because, you speak to quite a lot of landlords and you have a lot of landlords viewing your site, but even that is still quite a small percentage of the total number of landlords. So NRLA, for example, has about 100,000 members, but there's about 5 million landlords. So there's an enormous gap between the number of people that everyone together reaches and the actual number of landlords.
Well, this was discussed in the meeting, wasn't it?
Yeah.
And there was concern about how to reach the entire landlord community because they are going to need to be educated. I hope property tribes can play a part in that. But, for instance, signing up to the redress scheme, there's going to be landlords out there that don't know that they have to sign up to the redress scheme. And if you're not a member of the redress scheme, you can't serve notice anyway. anyway.
Yeah.
So, I still speak to people that have never heard of tenancy deposit protection.
Yeah, me too. I still get clients ringing me up saying, "Oh, my tenant said I've not protected my deposit. What's that about?" And I'm like, "Yeah, that's been around for a while." So the fact that something's been around since 2007, I think it is.
Yes, right.
That is still not. I was a trainee solicitor when deposit protection came into effect. So something's been around since 2007 is still not fully understood by the whole community, and now they're all going to be told they've got to sign up to a database, which I suspect many of them will just be cheerfully oblivious of.
And then we go back to that old chestnut of lack of enforcement, because the existing legislation and regulation isn't properly enforced.
Yeah.
And now there's new, much stricter, there's penalties, quite some serious, some £40,000, some even criminal instances of non-compliance. So it's going to be fascinating watching it all play out and how it's going to be enforced and so on.
Well, I think enforcement's a problem. I saw CIH, I think just yesterday, were calling for the government to increase enforcement money, saying we've got all these new responsibilities, how do you expect us to enforce them? There's a lot more rent repayment orders, so there's more incentive for tenants to directly enforce, but they've still got to hear about this stuff. And again, I think enforcement, as you say, has been really patchy to date. It's been described as a postcode lottery. It will continue, I fear, to be exactly that. And in some areas, there will be basically no enforcement at all, and in some areas, there'll be loads.
And then all the, ethical, responsible landlords are going to be put under pressure, have their margins slimmed because of all the extra expenses and worries. Many will leave, but then the rogues will just fly under the radar as they've always done.
Bad enforcement impacts twice. I mean, it impacts multiple groups. Obviously, it's bad for tenants.
Yeah.
It's bad in terms of combating rogue landlords, but lack of enforcement is bad for good landlords who actually are spending the time, money, and effort to do this stuff, while other people are effectively not paying the cost.
Exactly.
And of course it increases the cost as well on good landlords, because those costs ultimately get pushed back into license fees or redress scheme fees or whatever other fee you have to pay.
Indeed. Tenants have to give 2 months notice to vacate a property. That's good. I always thought 1 month wasn't really enough, in some cases wasn't really enough time to get a new tenant without experiencing a void, so that's
But again,
good.
I think that's a concern. A lot of tenants won't realise this and will think they can just go or can give unclear notice. And I think a lot of landlords are going to hold people very strictly to 2 months. As a lawyer, I often say to people 2 months means 2 months, and you often get people saying, but it was a couple of days under. And it's like, well, that's still not 2 months. 2 months is a very clear thing. And
so it could be more like 3 months.
It might be, but the reality is that a lot of people think when I say 2 months as notice, I mean about 2 months, when I mean at least 2 months. And I think many landlords are likely to be quite robust about insisting on 2 months notice.
Indeed. Well, the educated ones will be. No advance rent payments. Now, this concerns me, David, because this may restrict access to private renting for certain groups of people. Prime example, I have a family member who is mentally incapacitated, has been sectioned on a number of occasions, but has a very large amount of money from an insurance payout. In terms of affordability, they will never be able to access private renting because they don't earn any money. They can only secure private renting by offering advance payment. What happens in those instances?
I don't think there's an answer. I mean, I think the reality is that rental guarantee schemes are likely to be dusting off their products and pushing hard into the market. And I think you'll find that more and more landlords will turn towards rental guarantee insurance.
And you mean rent guarantee insurance?
Yes.
Yeah. Okay. Well, that's interesting. But I think they're going to have to change.
Oh, they'll charge more as well.
Yeah.
Obviously.
I think the charge of that's going to go up because with Section 21 going, it's not going to be as straightforward.
No, it will be more complex for them to get possession.
Yeah.
But obviously, if more landlords sign up, they'll hopefully be able to make it'll be a marginal gain for them. So hopefully, the prices won't go up too much. But I suspect they'll be pushing hard and making new offerings, and I expect many more landlords will sign up to those offerings.
Yeah. I think we're pretty clued in on the changes to Section 8 grounds for possession. There's lots of new ones. There's a new one if you're selling your property. Now this had me scratching my head, because if you serve the ground that you're going to sell the property and then for whatever reason you don't sell it, you're not allowed to re-let it for a year plus the 4 months notice to the tenant. So that's a potential 16 months that you can't re-let your property if the sale falls through or your circumstances change. Now, isn't there a housing crisis?
Yeah, I mean, if you're going to say you're going to sell, then you're going to have to sell, or it's going to have to sit. The only
It's
exemption
just
to this,
bonkers.
well, I think, the reason they've done it is to some extent the fault of some landlords who cheerfully turned around after the first reform bill and were very publicly saying, they would say they were going to sell. So it was almost inevitable there was going to be some aspect of enforcement to that. I mean, there is a defence to the thing, to say a reasonable excuse defence, and if you can legitimately say I genuinely changed my mind, it may well be that the courts will accept that as a reasonable excuse, and I suspect that's something that's going to come up at some point.
I will put a link to the Independent Landlord blog so you can actually dip into this in more detail, because we don't have time to cover everything. And we've also got a recording of David's brilliant presentation, which was actually to the lettings industry, as in letting agents and property managers, but is highly relevant obviously to landlords as well. The new procedure for increasing rent. You can only do it once a year. You have to do the Section 13 procedure.
I think that would be the biggest change of all. Landlords have to serve a Section 13 notice to increase the rent. Tenants can always take it to a tribunal for free, and if the tribunal deals with it, then the rent increases. It doesn't happen until the tribunal carries out its determination. So I think every tenant will pursue a determination before the tribunal, because the rent increase will only be the maximum number on the notice. It won't be anything higher, which is what the law is now. It won't be backdated to the notice date, which is what the law is now. So if you're a tenant, it's free to go to the tribunal. The worst that happens is you have to pay the rent on the notice, but 2 or 3 months later. So I suspect every tenant who knows anything about the thing will be making an application to the tribunal as quick as they can. I wouldn't be at all surprised to find that there will be groups, as there are now, who will be trying to do this work for tenants and take a cut of whatever saving they make as against the original Section 13 notice or something like that.
Well, that is a very significant change, particularly that they can take it to a first-tier tribunal free of charge.
Well, it's always been free to take a
they've got nothing to lose.
But yeah, it's absolutely. You, as a tenant, you'd always be crazy not to make full use of the system that's put in front of you.
Yeah. Now you have called this, and you've coined the phrase, rent
I've called it rent suppression. Yes. Well, it's not rent control.
It's not rent controls
because the rent is market.
Yeah, but you believe that it's kind of like taking the heat out of the rental market and just kind of suppressing rents a little bit.
Absolutely. I mean, there's always been the intention of government, both the previous government and the current government, to try and slow the market down, and this obviously does. If you've got to give 2 months' notice for a rent increase, which you do, that puts it 2 months down the road already. The tenant can then go to tribunal, which takes another 2 to 3 months to deal with it. That puts another few months down the road. So you slow down that speed of rent increase through the market. And of course, if rent rises in tenancy drop, then that has a knock-on effect in out-of-tenancy rent increases as well, because the market figure is then reset. So there's a subtle slowdown that runs through the market. And then if the tribunal is doing a determination, people always think of market rent as a number, but it's not, it's a band. And the tribunal may not be in the same place as the band as you are, and probably won't be a lower end of the band. So the reality is it will have a slightly downtreading effect on rent rises.
Okay. And then a ban on encouraging, inviting or accepting rental bidding. Well, all people are going to do is put up the property on the portals at the maximum price that they think the market rent is, and then maybe a little bit more.
But you should bear in mind that it has always been possible for tenants to take a rent at the start of their tenancy to the FTT as being over the market level for 6 months. That has been rewritten and pulled back into the Section 13 notice, and it's quite clearly the government's intention to point that fact out to tenants. So yes, I'm sure landlords will overmark rents and encourage bids up to, but the danger might be if someone bids your number and you give it to them, they might almost immediately turn around and drop your rent into the FTT. So you're going to have to tread a careful line between having a keen rent that people can bid up to, but if you go completely mad, then there's a huge incentive to take that rent to the FTT as well and have it marked back down again, and you might not get the rent you first thought of.
Okay, so well, we're just going to quickly...
We can talk about rents for hours.
Well, we can, and I do want to advise you to have a look at David's presentation as well, because it goes into a lot more detail. We know that the tenant has the right to request a pet. There's going to be the private rented sector ombudsman that all landlords have to join. There's the private rental sector database, the property portal, which we know about, the decent home standards, AWAB's law, no bans on children or benefit claimants, and that's pretty much it. So, David, how do you see the transition from the AST that we've known for so many years through to these new types of tenancies?
Well, it's going to be quite tough because you've sort of answered the question. People have known about it for so long; it's become so baked into the system that to go to a new system will require lots of people to completely rethink where they are. So that will be quite jarring for a lot of people. And then there's quite a lot of work to do in quite a short time window, really. I mean, next summer may feel like a long way away, but in parliamentary and legal terms, it's not a lot of time for every tenancy agreement in England to be replaced with a new tenancy agreement, for example. That's a lot of tenancy agreements. And there are only a certain number of people producing or writing those documents. There's only about 6 or 7 people who write most tenancy agreements in the country. Are
you one of them?
I am one of them, yes. But I'm hoping to have a holiday over Christmas, for example. I'd like to do something else occasionally. So the reality is there's quite a limited scope of capacity to do what is a lot of change. And landlords need to do training, agents have to do training, processes have to change. There's a hell of a lot to get our heads around, and not all that much time to make it happen.
Indeed. Well, I feel that another interview will be necessary in the coming weeks and months as we count down to the implementation of the Renters' Rights Bill. I feel like we've only just kind of scratched the surface in a way.
I don't feel that I know the whole bill yet, so you need to keep an eye on your favourite property website to keep going for the updates. Okay,
well, thank you so much for everything that you do in our sector, David, for your talk today and for also talking to us here at Property Tribes. And we will put David's presentation in the follow-up video to this one, so I would advise you to sit down with a cup of tea and just watch it and take it all in, because David has raised some very interesting points.